So today we're going to talk about, I called this one Estate Planning 101. This is not a nuts and bolts webinar. If you're looking for a conversation on the documents that make up an estate planning package, I've taught that before, and you can go to Rock Solid Law /videos, our videos tab, and look through there until you find the one that talks about the nuts and bolts of the various documents that are used. Today, I want to do a little more high-level discussion, more about the why and what estate planning does for you and for those you love. So, estate planning, in my opinion, is the way that we journal the heroic journey of our lives, and we set ourselves and those we love up for success in the future. Most people don't think of it that way. Hey, listen, when I'm in this area of my practice, I got both death and taxes in the room, right? So we're going to do our best with both of those subjects, and I say nobody gets out alive. That's a Jim Morrison quote. We're all going to die someday. And the process goes much better when you've taken the moment to plan for it. I will tell you that I have a new client who had been advised to see us, I am told, for over a year and a half and didn't. Sadly died this week with no plan in place, millions of dollars at issue, and no children, no living parents, and siblings that don't get along. Don't leave that mess behind. Okay, that's your first takeaway. Do not leave that mess behind. All right. So there are two essential ways to approach a basic estate plan. This conversation, being 101, is not going to be about sophisticated, irrevocable trusts that are for tax planning and asset protection. We're not talking about that today. Guess what? Those are at the videos too. So in thinking about your planning, you're going to think in terms of either doing a plan based upon a last will and testament or based upon a revocable or living trust. Revocable, for your purposes today, means you can change it whenever you want because you will reserve the right to do so. So as your life grows and changes, you can change your plan. Okay, what a last will and testament is good for. A last will and testament is good for establishing who you want to get your stuff after you're gone and who you want to put in charge of distributing it pursuant to the control and direction of a judge. Every last will and testament will in all likelihood end up in court unless you have a death beneficiary on absolutely everything you own. So when you have a last will and testament, you say who gets what, but you don't get to say when, because when is as soon as the judge says so and how the judge says so. So when I have this discussion with people, I'm often talking about, do you really want a judge, a government official, to be in charge of distribution of what you have left behind? And in some cases, the answer is yes. And in some cases, people say, well, look, I got somebody else on the deed to all my real properties. I've got death beneficiaries on every account I have anywhere. And I'm not worried about the fact that I will keep up with that from now until the day I die. And you know what? Other people say, you know what? I'll be dead. What do I care? It's going to cost my heirs money. It's going to cost my heirs frustration. It's going to cost my heirs time. And I may just have set them up with a format, a forum to fight. Because once that will is submitted to the court, it's really easy for somebody who wants to start an action against somebody else. Okay? So a will is good and needed for the basic distribution of your assets. When you have a last will and testament, and that is going to be the distribution of your assets, you all but certainly do not have a trust instrument as well. Okay? That's a plan built on a last will and testament. There are other documents that I'm going to talk about in this time together and what they do that are the same in both packages. But right now, I'm talking about the differences between choosing a last will and testament and choosing a trust package. So a revocable or living trust is an instrument wherein you control who gets what, how, and when. You will be, should you choose, and everybody does, the trustee during your lifetime, and if you're a couple, the survivor of you, so that those assets are there for you just the same as they are today. The way I say it is they're in your left pocket and you're moving them in your right pocket. But by moving those assets into your trust, your assets will no longer have to go to court, will not be subject to a delay in time due to the rules of probate procedure, will not be under the control and direction of a judge. Your heirs will not have the usually high expense of going through a probate action, and the inventory of your assets will not be filed at the courthouse and therefore subject to discovery by nosy neighbors and other people. All of these things are avoided by having a revocable trust. Additionally, you get to say, not my 18-year-old gets my millions of dollars immediately upon turning 18, but I'd like to pay for their education and then maybe give them a bump in the middle of their 20s, maybe some more 30, 35. I've had people go all the way out to 70. I've had 55, and I asked the couple why, and they said, because we want them to have a work ethic, but we want them to know that they're going to inherit what we leave behind so that their retirement is secured. I thought that was good logic. I'm agnostic on this subject. I advise and educate, and my clients tell me what to put in there. What I tell them is anything that's legal, I can put in there. We'll often put a clause in that if the trustee believes that the beneficiary, that's your heirs, your kids usually, or other people, have an issue with addiction to legal or illegal substances, that they can withhold payment. But that's your choice. Everything in that trust is your choice. And that's why I say it's writing your history, your legacy, your future. It's the story of your life. And through this trust, we can really pass your values down to the people that you love the most. People often ask, well, why didn't everybody choose a trust? Because doing a trust package costs about twice as much as doing a will package. However, that probate that's going to go with the will package, it's going to start at twice as much as a trust package. So it's, do I spend the money now, or do I cause the people I love the most to spend it later? People also ask me, well, when should I consider having a trust? Pardon me. By the way, I hope you have your coffee. Do I have enough in assets where a trust would be appropriate? I submit to you that I start considering whether a trust is appropriate for a family at about $300,000 in assets, and certainly at $500,000, lean in heavily toward recommending it. Anybody that's got assets of $1 million or more, the probate is going to be ridiculously expensive for your family and should be in a trust to skip the probate process. So that's just a rule of thumb. I've had people with less than 300,000 who are like, I don't want my kids fighting. I want the easy button. I don't want them to have to go to court when they'd rather be playing golf or tennis or music or whatever. I want a trust. That was a retired school teacher. And I said, yes, ma'am. If you own real property in Florida, there's a great likelihood that you meet the thresholds. Okay. So That's a choice, though, that you'll make. Do I want that level of control on the future of my assets and therefore need to trust? Or do I want to just say, when I'm gone, give it to whomever as soon as the judge is through? So I told you that we need to make a choice between a last will and testament based plan and a living trust based plan. So that's what I've talked about in the first half. Now, I think I'm going to talk about something that you may not have thought about. What are the things that are protected by having an estate plan that are not protected by not having an estate plan? First and foremost, in my mind, it's your legacy, how you will be thought of in the future. A saying that I just love is that you die twice. Once when you take your last breath, and the next time when the last person on earth thinks about you. You know, I think about my grandparents often for the things that they did in my life. They left an educational trust and helped pay for me to go through graduate school. I think of them fondly in that regard. When you make a plan and you leave a plan carefully laid out, instructing who gets what and when, you minimize the fighting that's going to go on after you're gone. I've given real estate speeches where a realtor came up to me knowing I'm an estate planning lawyer also after the event and said, guess what Uncle Frank did at the funeral? Right? And guess what? Yes, she had a not good opinion of Uncle Frank, but she also wished that her parent had taken the time to lock Uncle Frank out by expressing in a coherent document what they wanted done. So you create a great legacy for yourself, which is protected in large part from being sideswiped by somebody that you may not even be thinking of now, somebody that marries one of your kids later, who might take an action in the future if you permit them to, which will largely affect the way people think about and remember you into the future. So legacy is one of the really important things to be thinking of when creating an estate plan. Second, most people think about, I need to do a will. And I forgot to mention, when you have a will, you don't have a trust, but when you have a trust, you also have a will. It's called a pour over will, and that puts anything that you forgot to put in the trust into the trust after you're gone. Yes, a probate's required, so we want to get everything in the trust, but it's a much simpler probate and much, in my experience, less likely to have venom in the process. Still expensive, but so most people think I am taking care of whatever I leave behind and who gets it and how they get it and what I want done. But guess what? One of the most important parts of an estate plan is that it protects you. You are protected by an estate plan. I've already told you my opinion about how difficult probate is, and it's expensive. Stats will show anywhere between 10 and 60%. 60 can be eaten up in the probate process. Now, 60 is somebody who left a lot of debt behind, right? But every creditor gets a shot in probate, even fake ones. All right. So as much as I despise probate, a worse thing for you is a guardianship, because that means a court's going to appoint, while you're still alive but incapable of managing your affairs, who is going to take care of your stuff for you. And not only that, who's taking care of you, your body, your medical, etc. So the worst kind of thing to happen is a guardianship action. Quick story. I've told it before. Groucho Marx, Hollywood star, amazingly wealthy, couldn't be bothered to do any estate planning, outlived his capacity to take care of himself, and had to sit in a corner of the courtroom and watch people fight over who was going to be in control of his guardianship, mostly because they cared about who was going to be in control of his massive wealth rather than that they were truly concerned with him. And you know what? He died not long after that, and they got to go right back in and fight over it all over again in a probate. So by doing your estate plan and getting other documents done, you will never have to go into a guardianship during your lifetime, because you're going to choose who you would like to be your attorney in fact under your power of attorney, and who you would like to be your healthcare surrogate, and who you would like to talk to the doctors and nurses, and who you would like to be able to collect your medical records for you. And you're going to even say what you want your end of life care to be like, and at what point you're ready to be taken off the machines. Okay, so you are taking control of the rest of your life and deciding who you want to take care of you, instead of leaving it to a coin flip of the judge making a choice. Speaking of the coin flip, I've got a intestate. That means they didn't do a last will and testament, testament matter right now, where the person left two siblings, each of whom has an equal right under the law to be his fiduciary, his personal representative, which other states call an executor, under the supervision of the court. One of those two, he actually had to file a lawsuit against because of the way that sibling managed their parents' trust. So clearly, he would have wanted the other sibling, but we don't know yet which one the judge has got approved. Because you know what? The person that shows up at court, just like the person that shows up at an interview, doesn't always really reflect who the people really are. So that leads me to the last point of my discussion, which is, what do you need to be thinking about? And I know we've already started the chat, and it is about right there. So I'm going to try to leave just a few minutes to take some questions after I finish the next point. And so type them in there if you have them. If you've got questions, and often in estate planning we do, that you really don't want to share on a public chat, right? You may send them to us at questions, that's a plural word with an S on the end of the word question, at rocksolidlaw.com. And I or our other attorney will answer that question for you and get that information back to you. If it's very, very, very fact-centric, we may ask you to come in for a consultation so we can make sure that we give you the right answer. Anyway, what do you need to be thinking about before you come and talk to us or somebody else about creating your estate plan? You need to think about who your fiduciaries will be. What's a fiduciary? Doesn't it have something to do with somebody at the bank? No, it doesn't. Same word. A fiduciary is the person that you pick, that you trust. So the fiduciaries that you're going to need to think about, first and foremost, everyone will have a last will and testament, and you get to appoint someone that you're asking the judge to appoint as your personal representative. Remember, that's the person we also referred to as an executor or executrix from other states. That personal representative, or PR in Florida, is going to be in charge of filing your will with the judge, and with the judge's supervision, doing the things that you have asked them to do. Very important fiduciary. If you have chosen to do a trust plan, an equally or maybe more important fiduciary is your trustee, your successor trustee, because in all likelihood, you, and if you're married, the survivor, will be the trustee until you're incapable of doing it for yourself or you pass on. At that point, you have chosen that trusted person who you wish to carry out your wishes as set forth in your trust, and not under the supervision of a judge. So you have the personal representative and you have the trustee. Then you need to think of the next fiduciary, which is called an attorney in fact. It is not the same as attorney at law and does not have to be a lawyer. An attorney in fact is a person pursuant to your power of attorney who you appoint to take care of your basic business matters when you're incapable of doing so while you're still alive. Okay, so that's a really important person because you're going to still be alive while they can take actions for you. So you want to name one of those. A lot of times it's spouse, in case you had an account that you both weren't on. And then you name the next person in line as well. So picking one fiduciary and then the backup for your power of attorney. That's called an attorney in fact. Does not have anything to do with an attorney at law. Can, a lawyer's eligible, but not necessary. So the next, also power of attorney, in Florida, we call it a healthcare surrogate. This is your medical power of attorney. This is who you would appoint if you are unable to do so, to deal with the doctors and nurses and other medical personnel to make the best decisions on your behalf. It can be the same person as your attorney in fact under your power of attorney, but it doesn't have to be. In many situations, there's a person who's real good with finances. There's a different person who may have medical training or who just really has the same values that you do, that you would rather choose for your medical healthcare surrogate. In addition, you'll want to decide who should be able to have access to your medical records to be able to get them to your healthcare provider. And that those people, often multiple people, because it depends on who's able to, get busy and get that done, will be on your HIPAA release. Under federal law, we have to say who can get records, our medical records. Interesting point, while your healthcare surrogate can be in the conversation, through your living will or written declaration to physician regarding life-prolonging procedures, you're going to say at what point you want no longer to be supported by medical machinery. A lot of people refer to that as when do they pull the plug. You instruct your physician, who will be consulting with another physician, on when you have reached the final condition that you have set forth in this document, and that's when the decision will be made. It's very nice under Florida law, in my opinion, because you no longer have to make somebody else that loves you make that decision. Your healthcare surrogate will be part of the conversation, and in my life experience, the doctors discuss it with them, but ultimately it's the doctor who says, yeah, they said they don't want to be kept alive while they're once they're brain dead. Okay, if that's your decision, that's what will be carried out. So those are called fiduciaries, and people often ask, what can I do to prepare for my meeting? Well, a good awareness of your financial situation. Some people actually bring in spreadsheets, and a thoughtfulness about who you would want to take care of you. In many instances, and I'm a child of the 60s, right? So we don't want to pick people our own age or older. So it makes a lot of sense to be thinking in advance about who in the next generation might be eligible for that, because you want them to be around and capable at the time that they need to act for you, to take care of you. All right. So once again, if you have any specific questions, I welcome you to put them in the chat bar. I know I've gone a little bit long. There's just so much I care about on this subject. I want to, even before we do questions, thank you for being here with me. I guess Sly Stone would say, thank you for letting me be myself again. And so you can be your full self and do a very adult thing, as a lot of my clients mentioned that they may have procrastinated for years. For spending this time with me this morning, I would offer to waive the consultation fee for you if you want to come in and talk about your estate plan. A lot of adult children also bring their parents in to talk about their estate plan, which is a great thing, because if there is none, those kids are going to be the one managing it after the adult parent is gone. So what I will do, if you will mention to my team when you call to make an appointment, just mention you were on this webinar, and there will be no charge associated with that consultation while we talk about your particular scenario. So I cannot even believe that I have been such a model of clarity that none of you, and there are a lot of you on here, have any questions, but that makes me happy if I've been that good this morning. And I sincerely appreciate every one of you for joining us. You are so welcome, Robin. Thank you for your kind words and for joining again this morning. Well, if none of you have any questions, I hope those of you that have not yet done your estate planning will get in touch with us and let us help complete that prospect for you. Thank you, Lisa. That's great. I look forward to it. Who was it? Grant suggested, I have queued up a Beach Boys song because we lost the great Brian Wilson yesterday, who I think was the genius behind the Beach Boys. The Beach Boys were the only group that motivated the Beatles to up their game. And because of Pet Sounds, the Beatles went and did Sgt. Pepper's. And I like to say the Beatles are the reason the Rolling Stones upped their game. You know, they had that competition, at least in the press, but they were actually friends. And many of you probably know that the Beatles wrote one of the Rolling Stones' earliest recorded songs. In the same way, this song, Darlin', was originally written by Brian Wilson, God rest him, and thanks for the great music, for Three Dog Night to be one of their earliest songs. The song turned out so darn good that the Beach Boys talked him in to not letting Three Dog Night record it. Thanks, Grant. And the Beach Boys recorded it and, of course, had a huge hit. So this is Brian Wilson and the Beach Boys, Darlin'. I really appreciate you guys joining me this morning, being with me. And I played it years ago in a band. I hope everybody is surfing USA. I'm John Miller, founding attorney, senior attorney, Rock Solid Law and Title. Have a groovy day. Thanks, Brian Wilson, for the music. All right. In addition to Surfing USA, my band used to play rock and roll music, the Beach Boys version, and Sloop John B. All right, guys, that's it. I'll see you next time. Thanks for joining. Take care.